Hello. Classification of law. The law is classified into state law or federal law, civil or criminal. When we refer to federal law, we're looking at the United States Constitution with the 7 articles and the amendments, a federal statute, or a regulation of a federal agency. State law is going to reflect your state constitution or a state statute or a state administrative regulation. So it falls into those categories. That's how we start off the classification. Now, the 10th Amendment and federalism says that Congress can enact legislation only if the Constitution has given Congress the power to legislate. If the Constitution has not given Congress the power to legislate, then those powers are reserved to the state. That's the 10th Amendment. Now, the powers listed in the Constitution that give Congress the authority to legislate are known as the Necessary and Proper Clause, the Interstate Commerce Clause, and preemption. Necessary and proper means if this is necessary and proper for carrying out the Constitution, okay, into execution. So things like levying taxes. It is necessary and proper for us to levy taxes. It is necessary and proper for us to assess how much they are and all the things that go along with that, maintaining the roads, necessary and proper. Interstate commerce. Interstate commerce deals with money that travels across state lines. So in the textbook, they discuss how discrimination in public places was addressed using the Interstate Commerce Clause. The reason being is that people travel. So if Professor Grimes travels from the state of Maryland down to North Carolina, I may gas up in Maryland, gas up again in Virginia, stay in North Carolina. That's going to be my money comes from Maryland and it has traveled with me across Virginia down to North Carolina. That's interstate commerce. And because of that, they were able to use the Interstate Commerce Clause to address discrimination in public accommodations. Preemption says the federal government's power to prevent states from passing conflicting laws. What that means is that if there's a conflict between a state and a federal statute, the federal statute prevails. You see this played out in your Gonzalez case because while we have state and federal as 2 classifications of law, simply because one classification, meaning the state, legalizes something does not mean that the federal government has somehow legalized it as well. It's going to trump the state law. So when we talk about legalizing marijuana, there are states, California is one of them, the Gonzalez case discusses this. California has the Compassion Act. The Compassion Act says that if you have a medical illness which requires documentation and your doctors have said that you need marijuana for medicinal purposes, then you are allowed to do that. Some people grow it, they go and they purchase it, but it is under prescription and it is regulated. But it is not a crime if it is for medicinal purposes. That's the California Compassion Act. But it has still not been legalized on the federal level. So while you are in the state of California observing California's law, you are still violating the federal law that says it is considered a controlled dangerous substance. Yeah. Because the 10th Amendment says that if the Constitution has not given Congress the power to legislate, then the power to legislate has been reserved to the states. So what we see is that the states now have the ability to legislate their own laws, hence how we get state law. States, and even in areas where the federal government has the power to legislate, state law can give their citizens additional protections. So while the federal government sets the floor, the state law can increase it to the ceiling. So if federal law says we have the right to be secure in our persons and our papers under the 4th Amendment, requires a warrant, and there have been cases on the federal side that interpret what that means in terms of students and in school and how it is just reasonable suspicion. If your state wants to increase that and put in legislation to give their citizens more protection, they can do that. They can't do less, but they can always do more. So if there's a federal mandate that says all hospitals have to have 10 beds, well, the state can give 20 beds because you can do more, you just can't do less. If the mandate is for 10, Maryland can't introduce 5. Okay, so that's going to be state and federal. So you have your state law, just like federal, you can have state constitution, state legislation, and state administrative law. And just as a reminder, the administrative law is usually a branch of the under the executive branch. It is designed to enforce the law. So the courts interpret, the legislative branch makes the law, the executive branch enforces, and they enforce the law using administrative law and the administrations that address that. So, classification of criminal versus civil. How do we tell criminal versus civil? Just by the type of harm. A civil harm is against a person or a company. So it'd be Grimes versus Grimes or Grimes versus Pepsi Cola. A criminal case, you have wronged society. So it is the state of Maryland versus Grimes or the U.S., United States versus Grimes. That's how you tell, just looking at the title of a case, the party name, whether it's civil or criminal. The wrong in a civil case is against an individual or a company. The wrong in a criminal case is against society. The standard of proof. The standard of proof in a civil case is either the preponderance of the evidence. Preponderance of the evidence means it's about 51%. And again, outside of this class, percentages are not going to mean anything, but I use them to demonstrate just about what you have to prove. So the preponderance of evidence means it's more than likely that you did it. Okay, that's your 51%. That's in the civil case. There are a different standard. There's also what's called the clear and convincing standard, which has a higher threshold, and let's say about 75%. It's higher than preponderance of evidence, but it's not to the same level as in a criminal case. In a criminal case, the standard of proof is beyond a reasonable doubt. That should be about 99.999, if not 100%, that the person has committed this crime. Okay. Judgment. In a civil case, you are found liable or not liable. In a criminal case, you are found guilty or not guilty. You are never found innocent. Because in a criminal case, as well as in a civil case, the person may have actually committed that wrong, but maybe the burden of proof has not been met. So in a criminal case, maybe Professor Grimes did go and pull a gun, or she assaulted someone, but they have no witness anymore, and it's my word against the other person's word, and they can't get to that burden of proof. Or maybe Professor Grimes was a drug dealer and they found drugs, but they seized it illegally, so the drugs had been suppressed, and now they don't have enough evidence to meet the beyond a reasonable doubt standard that I was a drug dealer or that I've committed this offense of possession of CDS. Okay, sanctions and remedies in a civil case. In a civil case, you are looking for money 9 times out of 10. Sometimes a replevin, which means that someone took some property that belongs to me and I want it back. Or you may be asking someone to halt something. But for the most part, if we're suing in a civil case, we're looking for damages. Damages is a monetary award. And in a criminal case, we are looking for a person to be imprisoned, probation. There can be you can get incarceration. There are a number of different remedies or penalties assessed in a criminal case. Okay. Now, double jeopardy is often discussed. People make reference to double jeopardy, like you can't be punished for the same crime twice. Now, this is true, but they often leave off in the same jurisdiction. And what that means is that if I am being charged in a criminal case, and let's say the jury has been seated, okay, and at that particular point, if I'm found not guilty, I can't then be tried again in that same case under the same set of facts if I've been adjudicated. Now, you can appeal. You don't. Now, the state is not appealing simply because they lost. There has to be an appeal, which you should have learned in Chapter 2, based on questions of law. not questions of fact. But when it comes to double jeopardy, it attaches when the jury is seated. But then if those same set of facts can bring a civil suit, they're not precluded. It's not double jeopardy to have a civil suit because that's in a different jurisdiction. So to give you an example, O.J. Simpson. O.J. Simpson was charged with killing his wife. He was found not guilty. They then brought a civil suit. Same set of facts. He was only alleged to kill his wife once. So at that particular point, we're now in the civil jurisdiction, and they found that he was liable because the standard of proof is lower in a civil case. A case can be brought in state criminal court, and it can also be a violation of federal criminal law. So if someone goes into a bank and robs the bank, if the bank is FDIC insured, then if they did it in the state, that is a state criminal offense as well as a federal criminal offense. But we're not being charged in the federal twice or the state twice. We can go and you can be charged, okay, and tried in different jurisdictions. So sometimes, I don't know if you remember, but Baltimore City has a gun exile program. And so possession of a handgun is a violation of state law, but it's also a violation of federal law. So you can be charged on the state level, you can also be charged on the federal level. Okay, criminal law. So when we talk about criminal law is either classified as a felony or a misdemeanor. A felony is a more serious offense. The textbook definition says that you would get more than 1 year of time in prison, but it's actually based on the statute because you can actually be in jail for waiting for your felony case to be heard, and then you can have a crime that one believes to be a serious offense, and the statute says that it's actually a misdemeanor. So handgun violations in Maryland, use of a handgun in the commission of a crime is a misdemeanor, but you can get 5 years worth of time for that. So it really just depends on the statute. A misdemeanor is a less serious offense. And when we talk about criminal law, we look at the mens rea. There's certain elements that have to be present. Mens rea, that's the guilty mind. Actus reus is the guilty act, and causation. Those are the minimum elements that have to be present for this to go together. So did you have the guilty mind? Now, guilty mind and the actus reus is the intent. So some criminal charges require specific intent. Specific intent is going to be your first degree premeditated, willful, deliberate offense. That's your specific intent. You meant to do it. The actus reus is, did you do it? Did you actually do this act? And then the causation is the act that you committed, were you the cause? So if you killed someone, did you cause the death? Those things go together. All elements need to be present in order for me to be found guilty of that offense. So each offense has its elements, and we have to make sure each element is met. Okay? And that is how you establish a prima facie case against an individual. There are some defenses, but a defense is just that. Defense doesn't mean, well, it was self-defense, so I get to go home. It means that if there is a proceeding and we have a trial, then your defense may be self-defense. And then you have to argue that you were defending yourself and go against the various elements. Now, civil law. Civil law, the cause of action that they mention in your book is duty, breach, causation, and harm. That falls under torts. So the 4 elements in a tort is duty, breach, causation, and harm. And all 4 have to be present. So if Professor Grimes goes to drop off a prescription at the pharmacy, puts in the prescription, the pharmacist calls to say your prescription is ready. I return to the pharmacy, pay my copay, and I'm on my way home. I get to the house and I receive a call from the pharmacy saying, Mrs. Grimes, please do not take that medicine. If you take it, you will die. It is heart medication, and based on your age and weight, it will do severe damage to you. Do not take it. Well, the question becomes, can I sue? Has the pharmacy breached their duty? Okay, the civil analysis, duty, breach, causation, harm. Did they have a duty? Yes, they had a duty to give me the correct medicine. Did they breach it? Yes, because they didn't give me the correct medicine. Did they